Hello and welcome to LawPod. I am Ethna Dowds, a senior lecturer in law here at Queen's University Belfast, specialising in the area of sexual violence. And I'm joined by Professor Julia Quilter from the School of Law in the University of Wollongong, Australia, who has published widely in the area of rape law reform and is currently leading the Australian Research Council funded project Intoxication Evidence in Rape Trials, a Double-Edged Sword. Professor Quilter joins us as an invited speaker at our upcoming conference on reforming legal and policy responses to investigating and prosecuting sexual violence that is taking place over the next 2 days. And I'm delighted to be able to have a conversation with Professor Quilter in advance about her ongoing research in the area of rape law reform. So now that I've given the brief introduction, Julia, do you want to tell us a little bit about what actually brought you to this area of research?
Well, it's quite a long story, but I'll try and make it not too long. Really, I started doing a PhD in the area back last century, back in about 1995. And so what I was interested in back then is how the offence of rape has changed historically over the years. And so I went all the way back to the Hammurabi Code and the Bible and looked at it all the way through to modern time. And one of the things that was interesting to me there was just the stabilities, the great stabilities in the way the offence has been constructed over time. And once you get to kind of the modern times in Australia in particular, we actually see very similar sorts of things, for instance, about resistance and about real rape kind of attributes. So that was the PhD, and then after I finished the PhD, I promptly went off into practice and practiced a lot in criminal law, where I saw a lot of issues to do with, we call them sexual assault in New South Wales, so sexual assault trials. And I guess the experience of being a practitioner and seeing, once again, problems with these types of areas. When, after a decade of doing that, I went back into academia, I came back to the area of rape law reform. And really off the back of a project on intoxication in criminal law more generally, we discovered that in the area of sexual assault law, intoxication evidence was used very commonly in relation to attacking the credibility of the complainant. And so we then, off the back of that, did a new project, and it was the one that you've mentioned in the introduction today. So it's been a long-term trajectory of mine and an interest, and, I'm still doing it today.
Yeah, thank you so much. That's been really interesting to hear, because I think what you talked about there, the construction of the crime and the terminology, and even when you mentioned about how it's referred to as sexual assault in your jurisdiction, because I suppose I often refer to my work as speaking just to the crime of rape, but it speaks to all different forms of sexual assault. And as you've mentioned, in some jurisdictions, the label rape is no longer used as the catch-all. So I think it's going to be really interesting to hear from you about your current project as well, with the trial transcript analysis, particularly because that's a research method that is quite rare to get that access. And I know from my own research, so as I said at the beginning, I specialise in the area of sexual violence, and most recently my research has been very much focused on reforms in Northern Ireland, so my own jurisdiction, following the high-profile rugby rape trial that happened in 2018, featuring 2 high-profile Ulster and Ireland rugby players who were accused of sexual assaulting a young woman at a house party, and their subsequent acquittal, which then resulted in the 2019 Gillen Review into serious sexual offences. And as part of my research, I gained access to some of the transcripts from that trial, but that trial had went on for weeks, and I only got access to a very redacted version, so had to then use media articles to try and compensate for that, because it was heavily publicised. And it was really interesting to actually just see there on black and white paper what was spoke about, even though, people could have sat in court and watched it happen live. I was reflecting on it a lot later. So I wonder if you could say a little bit about what your research on trial transcripts has shown you in terms of giving that unique insight into what actually happens in the trials.
Yeah, look, I think one of the really important things is that you're right. It's very hard to access transcripts, I think, in no matter what jurisdiction you're in. And I guess as researchers, we were very fortunate to access a large number of trial transcripts in our 2 largest jurisdictions in Australia, that is in Victoria and New South Wales. And that was part of the Australian Research Council grant. But fortuitously for us, there were a number of inquiries going on in Australia. And so we ended up really being commissioned to do some of this work, firstly by the Victorian Law Reform Commission and then also by the Department for Communities and Justice in New South Wales. And I think it's fair to say that that really facilitated our access to the transcript. So that's the first thing to say. But in terms of the actual trial transcript research, so profound in terms of just looking at the disconnect between the huge 50-year progressive law reform project and what's still going on in courtrooms today. And it's not just the Defence Counsel who are continuing to draw and frame their cases and cross-examination around real rape attributes, it's also the Crown. And so I guess for us, one of the most significant findings from our transcript research is that very little has changed in terms of the types of the content of the questions. Certainly how questions are asked, things are much more polite, I think, in the communications in the courtroom, but the content of the questions is really not transformed at all, which, is a real disconnect between this very long trajectory of progressive law reforms. I suppose more positively, and I always like to have a bit of a positive story, is that one of the things we also found from our trial transcript research was that there are a number of reforms that have been introduced that are working very well. So that was also a positive news story in terms of alternative mechanisms for giving evidence, support persons being present for complainants, closed courtrooms, non-publication orders, those sorts of things. They're operating in every trial, really, in Australia.
Yeah, well, that's because I was going to ask you about the anticipated impact of reform versus what you actually saw in the transcripts. So it was interesting that you said there that, given the 50-year period, because I suppose the reforms that I've most recently been looking at, like I said, were in Northern Ireland, occurred within the context of the Gillen Review, but that sits, there's a lot of consultations, reviews, different things that sit behind that. And it's the same then in Australia as well. And one of the persistent issues is that of rape myths. So these stereotypical attitudes. And like you say, many people will maybe assume that it comes from the defence. But in your experience, you've seen it being used by the Crown as well. Do you have any examples that maybe spring to mind as to what you mean whenever the Crown, the prosecution, might rely on rape myths?
So look, I think the trial is framed by the Crown, of course, and their framing of the case still orients it towards whether or not the complainant resisted, both verbally and physically, whether or not she immediately complained, so told somebody about the rape and did that very quickly after the events, whether or not she was distressed following the event. And so often witnesses are called to show that, they saw the complainant crying or being very distressed or not her usual self. So those sorts of real rape attributes, as we might refer to them, or the misconceptions that you have to demonstrate resistance, you have to immediately complain, you have to show distress, were all very present in the Crown's case. So very little has changed in terms of the way the Crown frames its case. And so perhaps not surprisingly, the defence play the other side of the coin, the absence of resistance, the absence of distress, the absence of immediate complaint, those sorts of issues.
Yeah, and this all then, because my research looks at the definition, so like you talked about at the beginning, when you were talking through your background, the construction of the offence itself, and there's been a lot of changes there, so really, on paper, there shouldn't be a focus on resistance in the way the definition of rape or sexual assault has evolved in our jurisdiction. And I'm sure it's the same in jurisdictions across Australia. And recently, for example, in the Gillen Review, there was some attention to this on how we could maybe reconstruct the notion of consent or how the narrative might play out. And one part of that was to try and put a little bit more of a focus on the actions of the perpetrator. So maybe we could talk about that a little bit, because I know that when I was researching, I was trying to look comparatively and I was interested in what was going on in Australia and some of the moves across various jurisdictions towards affirmative consent notions. So maybe trying to think about consent as something that is manifested physically or verbally. And then also in the Gillen Review, for example, within our current definition of consent, if we are looking to prove the defendant's guilt, we have to explore whether they reasonably believed that the complainant consented, and the jury can consider any steps the defendant took to ascertain the complainant's consent when determining whether their belief was reasonable or not. And Sir John Gillan wanted to make a slight amendment to that and to focus on the defendant's failure to take steps, but not say that that ultimately meant they were guilty if they failed. It's just, again, a consideration. But I was wondering if you had any insights from reforms that were occurring to consent across Australia, and whether you thought reforms to the terminology that is used would have an impact on trial narratives.
So it's been the big question. So we've moved from, concept of consent meaning, well, in the past it had to be against the woman's will and to demonstrate resistance, towards a concept of communicative consent. So the idea that people would mutually discuss sexual relations and that there would be consent in that form. And as you point out, the most recent iteration of this is a move towards affirmative consent. In a number of the jurisdictions in Australia, we've now got models of affirmative consent, and what that is based on is it really looks at the fault element for the offence in Australia, and that in order for a belief to be reasonable in consent, they have to have done something or said something in order to affirm that consent. And so that's been the key kind of change that has happened quite recently. So 2022 has been the point in time when Australia started reaching for the concept of affirmative consent. I guess in terms of the trials that we looked at, one of the things that was very obvious from the outset is that most trials are run around different poles of the idea. So on the one hand, the Crown says she didn't consent, and on the other hand, the defence runs a case saying, no, she was actively consenting. And so if you look at the kind of ways in which trials are actually run, I think there's actually a very limited role for the concept of affirmative consent to play, because most of the time, first of all, we don't have accused persons giving evidence. But secondly, the case for the defence is that they were actively participating the whole way through. And so if you look at how trials are actually being run, I think it's going to be a very small number of cases where the concept of affirmative consent will change what is actually going on in the trial. So I guess that's a fairly depressing sort of conclusion to make, but I suspect that we've spent an inordinate amount of time getting the definition of consent right, but it's just not having traction in the courtroom.
Yeah, well, I think that because in my research anyway, I try to go between those two poles, as you say, because there's a lot of optimism, I suppose, around what affirmative consent might be able to do. And it also, I suppose we have to think about what it might do as a legal tool versus as an educational tool as well, and what way we want to use it. But the way you described what you've seen in the trials and how they're run reflects some of the empirical work that I done just after the Gillan review, where I talked to practitioners about the definition and the potential of this change. And that was exactly what was said, that, well, in the case, the defence aren't going to say, well, okay, she didn't consent, but they believed. The case is she did consent and it was obvious, versus, so the case falls on whether there was consent or not whether there was the belief. So, yeah, it's something that we've been trying to get right, as you say, and whether it what happens in the trial is a different story.
And certainly, I guess, in the trial transcripts that, we were reading, is that it's very much focused on the active nature of the complainant most commonly. So she was the active participant is typically the way in which the cross-examination of the complainant falls out. So she was the active person taking off her clothes. She was the active person taking part in kissing or touching the accused. So when you have a trial running on these kind of polar spectrums of Crown saying, no, she didn't consent, she didn't do any of those things, and the defence saying, actually, she was the active participant in all of this, it's difficult to see the very small number of cases where a concept of affirmative consent is going to come into operation. And also, too, it's quite limited. What does it mean to say something to affirm consent. So it could be a very limited thing, or to do something. So what if you move or you ask the other person to move and they move? Does that mean that they're affirming consent? And that's certainly something we saw in a number of the trials that we were reading, that, when they were actually cross-examined by the Crown saying, well, what made you believe that she was consenting? Oh, well, when I said, change positions or do this, that and the other, she did in fact do that.
Yeah, well, that's really interesting, even something that I'm thinking about at the minute as well, because two things you said there. One was about how the focus is on the complainant and the acts that they were doing, which is also a danger of affirmative consent. If affirmative consent, you're looking for it to be expressed in some way, then the defence can say, well, she took her clothes off, or she did this, or she did that. And the other thing is, how do you evidence someone saying or doing something to ascertain consent? And in Northern Ireland, it's the language of taking steps, which is slightly different, but it's the same idea. And in my empirical work that I talked about earlier, I had spoke to participants about, how they understood that concept, and there was very limited understanding of what it meant, in what circumstances, and even then, if someone does take a step, because it's only consideration, what does it really mean at the end? So there's the terminology on the one hand, and then how it's interpreted and applied. And that also goes to the issue of, we don't know what juries are doing. So this is the big question. And we have extensive mock jury studies that, give us an insight into how people might discuss these issues in a group environment, but we don't have the access to the real jurors to see what goes on. And I wonder to what extent you use that in your own research in terms of these mock jury studies, and how that reflects in your thinking on some of these developments.
So it's a great question, and, the area of what juries are thinking and doing and deliberating as well in Australia, they are secret, the deliberations. Typically we don't speak to jurors, and certainly none of my research has been involved in speaking to jurors. Has been some studies done in both New Zealand and Victoria, I imagine you're aware of those, where they did actually speak to real jurors, and there were some important insights that came out of that, which I think it's fair to say in summary suggests that rape myths are alive and well in deliberations. But from our research point of view, I guess the aspect that we were focused on was the types of jury directions that were being given. And a big shift, of course, in law reform in this area has been to introduce so-called educative jury directions to attempt to overcome rape myths and to inform jurors of that. And in Australia, we've moved from a situation where we had one or two jury directions, so one about delays, explaining to juries that there may be many good reasons why a person delays. After that, we had what's known as the consistency or differences in accounts direction. And that relates to saying, look, the normal way in which memory works is that there will be gaps. There will be occasions where things are inconsistent, but that doesn't mean you can't believe the person. From 2022, we've now got a range of other jury directions that have been introduced around the concept of consent. And in Victoria, I think we're up to 12 different types of jury directions being given to jurors. And I guess from our point of view, there are important things about those jury directions, particularly if they're used early on and what we would refer to as mid-trial, so after relevant evidence is given, not just left up to the end point of the trial where the judge is summing up the evidence and directing the jury in terms of law. We think that they should be used often and more commonly after the relevant evidence has been given to have the most impact. But nevertheless, we still don't really know how jurors are receiving those directions. And certainly from a number of the directions that I've read, they're complex. They take a long time, and we don't really know whether or not jurors are able to concentrate and, analyse and think through all of those things that they're being directed on. We had some directions going for a whole day. I mean, as teachers of law, we would not put a student in a situation where they were effectively being lectured to for between 9 and 4 o'clock in the afternoon, with any thought that they might not be doing other things like Facebooking and doing anything else. So there's a big question there about how are these jury directions actually operating to inform jurors.
Yeah, this is something that came out again in the research that I had done, where one of the participants had noted about the amount of information that an unsuspecting jury has to take in during a rape or sexual offence trial. And it was around this discussion of jury directions, because in this jurisdiction, as part of the Gillen Review, there was discussion. Rape myths cut across a lot of the chapters, but there was one particular chapter that was looking at the role of the jury and taking into consideration the concerns around rape myths. But there has been no studies really here in Northern Ireland. We have one of our colleagues, Dr. Rosie Cowan, who for her PhD, she undertook mock jury research, and that's been the first one in Northern Ireland, whereas often when we're looking for our evidence, we look to research that's been carried out in England and Wales, for example, because our legislation would mirror one another. But jury directions in this jurisdiction, it was one thing that was talked about, as well as like myth-busting videos, for example, these educational tools to help educate the jury, as opposed to removing the jury, which is an option that is often comes up in the debates. Recently in Scotland, for example, I'm sure you saw that. This was going to be piloted non-jury trials, and then practically the legal professionals weren't on board with that. So the direction of travel in that area, I suppose, is very much around educating the jury. But like you say, to what extent is that information taken on? And is there a danger of overloading people with information?
On that, when I speak to judges, they all say, look, I would prefer to sum up and direct in a murder trial. It's easier. Whereas when you sum up and direct in a sexual assault or rape trial, it's so complex. There are so many directions now to give, and they take a long time. Now, of course, some of the judges, that when we read their directions, they managed a very good line between keeping it reasonably simple and focused. But then there were other judges that gave back-to-back directions that were often also contradictory. So being a juror must be a very difficult exercise when you're receiving that sort of information.
Yeah, and then there's a danger as well, isn't there, with the jury directions, in that they could become the point of appeal for the defendant, for example. So judges have quite a delicate line to balance there in getting the directions right. And
that's exactly why they direct on every single issue, because it may or may not be the same here, but rape trials are the most, if you do indeed get a conviction, and we know conviction rates are fairly low, but to the extent that you get a conviction, they're the most appealed type of matter, and often about the types of things that the judge said to the jury, whether or not they gave this direction or they overstepped in terms of that direction. And so you're right that judges are very cautious, I guess, in the way that they direct and try to cover every single issue and make their direction appeal-proof.
Yeah, I know. There's so much to think about, I suppose, whenever, you sometimes people see these trials, being written about in the papers, or they see it in the media, and then when you get into the nitty-gritty of it, there's just so much to think about. And on that, I suppose, there has been quite a tension in relation to the complainant's rights versus the defendant's right a lot of the time in these trials. And they're often seen, because we're working within an adversarial context, that they're in opposition to one another. But with the contemporary reform in this area, we have seen a lot of reforms being introduced that are trying to make the court environment a better place for the complainant. So in Northern Ireland, for example, we have recently had the introduction of sexual offence legal advisors, who are there to advise the complainant pre-trial, mostly in relation to disclosure issues relating to their medical history and also their sexual history. And it's recently been introduced in respect of children as well. And we have remote evidence centres, for example, where the complainants can give their evidence via live link away from the court. So there is an appetite to try and make the courtroom environment, or the criminal justice process, as I say, a better environment for the complainant, and to reduce the secondary victimisation that we often hear about. And I wonder if you could speak a little bit, I know that you mentioned a bit earlier about some of the reforms that you've seen that are working well, but those more procedural aspects in terms of the running of the trial and how they will impact the complainant positively, hopefully.
Yeah, look, we found that in the trials that we were looking at, that the general procedural changes that have been made and the measures to improve the complainant's experience of the criminal justice system were working well. Pretty much in all of the trials, complainants gave evidence remotely, so via CCTV. In all trials, they had a support person present with them. Closed courts were just universal. Occasionally those things were breached by, a member of the public walking in despite the closed court. They were pretty much ordered out straight away. And also non-publication orders were made in all of those sorts of matters. So those measures are working very effectively. There were at times things like technology hiccups. So sometimes the AVL link didn't work as well as it might. Sometimes cameras were not well located, so they might have seen the top of a barrister's head or had to then manually manipulate the cameras themselves. Sometimes documents weren't either in the remote location or weren't easy to navigate for the complainant. But generally speaking, I think there was a very strong commitment to complainants being able to utilise universally these types of general measures. In Australia, there's also a number of specific measures that only arise in certain types of matters. So, for example, one of those protections relates to a complainant can't be cross-examined personally by an accused person. And that was a measure that was adopted in New South Wales after a pretty awful matter where the accused sacked their lawyers and the complainant said they were not going to continue to give evidence if they were to be personally cross-examined. And so measures were introduced to prevent that happening. We had that in a couple of the trials that we looked at, not very many, but again, those measures were working as intended. Somebody was appointed to ask the questions on behalf of the accused and a complainant wasn't cross-examined on those. We call them, another measure that you mentioned, I think, was about sexual communication privilege. So if you've gone to a counsellor, for example, or you might have had some medical notes or other things that are confidential communications, we've got provisions in New South Wales in particular to ensure that there is a process for the Crown protecting effectively a complainant from being asked or having any of that information revealed. And so separate representation through legal aid is appointed to the complainant, and basically there's a privilege at the outset, so there's a prohibition, and that was working effectively. It's very rare for Defence Counsel to get hold of those records as a result of those kinds of measures. It does happen, and sometimes there's agreement by the complainant that a certain portion of those records can be disclosed. So we did find those measures were largely working as intended, which of course we do hope that that will improve the complainant's experience and reduce re-traumatisation.
Yeah, no, it sounds like there's some parallels there in terms of the protections that are offered to complainants across jurisdictions that you've explored, then also here in Northern Ireland.
I think you're right. And I think really, yes, each legislature is enacting and changing and reviewing their laws at times in isolation. But I think in this area, because there has been such a long history of progressive reform, I think whenever legislatures are enacting or inquiries are made, they are looking what's happening across the world, particularly in the common law world. And certainly in Australia, our different jurisdictions all have differently expressed legislation, but we are moving towards effectively a harmonisation across the types of measures, and I would not be surprised if similar sorts of things are happening over here.
Yeah, because I think definitely any consultation that I've explored, there's always been that comparative element to it, and there is this idea that everyone is working towards the same sort of, legislation, and that there will be some harmonisation there. The other issue I wanted to mention is something that I've been working on quite recently, and it's in relation to the way the good character of the accused is used in sexual offence trials. So this actually is a topic that didn't feature very much in the Gillen review. It was mentioned very briefly, just in the sense that the defendant has the right to call, character references, whereas the complainant is not generally. And, as we know from what we've seen and the research that is going on, often these trials come down to credibility of, the parties. And from your analysis. I was wondering how you saw that feature, because the research that I have done has been, I suppose there's been no first-hand, but I've been able to draw from different court observation studies, for example, that have seen this, like good boy defence trying to be used quite often, and a number of character references being used to paint the defendant in a certain light. And I would argue that often it relies on these stereotypes around what a rapist looks like, or what is a stereotypical monster rapist versus the good guy who has possibly made a mistake, crossed a line, but not necessarily committed a sexual offence. And I was wondering, through your research, the transcripts, for example, have you seen that come up, and what are your thoughts on that?
It wasn't a strong feature in the transcripts we looked at, but on the occasions where it did come up, it was very similar sorts of themes. So typically friends of the accused, or parents of the accused, or family friends, or a coach, or somebody in some sort of position of authority was called by the defence. And, from, I guess, an observational point of view, reading some of that evidence, it was a very kind of, big call to make, to say, this mother had experienced this child coming to their house, for many years, and had never seen anything inappropriate that he had engaged in, to saying, well, hold on, how does that relate to the specific instance where they're at a party or at a nightclub, they're all drinking, how are they actually engaging on that level? So there wasn't a lot of interrogation of the good character kind of evidence. I suppose some of the better cross-examination from the Crown was to elicit short, sharp questions about how the evidence that they were giving deviated from the particular circumstance in which the case was involved in. So saying, well, have you ever observed this person in this particular circumstance? And typically the answer was no. And so I guess a good Crown could cross-examine that defence evidence quite well. That said, there does seem to me something strange about how that evidence is considered relevant and appropriate and admissible when it really has nothing to do with the facts in the issue.
Yeah, because whenever I was looking into the area as well, it was Rape Crisis Northern Ireland who brought this issue up. It was a couple of years ago, I think it was after the Gillen Review, but noting it as a missed opportunity that this wasn't part of the Gillen Review. The Law Commission for England and Wales, they have a chapter on it, so they're currently reviewing their law and procedure on serious sexual offences. And I looked at some of the discussions there, and I think that this again is where that adversarial tension comes up, because when I was exploring it, it's the fact that the defendant, by virtue of being on trial, there's biases there that can come up. So the good characters to try and offset that, and there's fair trial rights. But as you say, the way in which it's used in these specific contexts, and because of the secondary victimisation that is often experienced by the complainant, and that very big imbalance that becomes obvious in these trials, you do wonder about that type of evidence. So I was trying to look and see what reforms are being proposed, and there seems to be a lack of appetite to remove that evidence on the part of the defendant. There was some recommendations that were proposing allowing more complainant good character evidence. But again, you run into difficulties there, because that could just cause more intrusion into the complainant's life. And also there's so much problems with the length of these trials, the delays, different things. You could have satellite issues. So my research actually then moved me to think about how it features at sentencing as well, because it's something that can be considered as a mitigating factor, for example. And that's something I have argued I don't think should be the case, because I don't think someone's good character should have any impact on the length of sentence that they have or the severity with which it is treated. And from my research, I saw that it was a Queensland Advisory Council were looking at this issue. I don't know whether it's something that you have seen or looked at from that point of view of the sentencing.
I guess the main area it's come up in is in relation to child sexual assault matters in Australia. And of course, after our Royal Commission into Institutional Abuse of Children, there was a very strong push, and now it can't be taken into account in sentencing that, this particular person was apart from, in inverted commas, apart from the offending for which they've been convicted, otherwise an upstanding and good member of society, that no longer can be relied upon in such a profoundly intense way to reduce the sentence as it could in the past. How that translates in the adult context, I don't think we've got a particular consensus in Australia at all. I think that many judges will look at good character evidence but not necessarily rely very heavily upon it because they're fairly aware that the evidence is given for that particular purpose and it wouldn't be coming out unless they were trying to mitigate their sentence in some way. So I think it's only a factor within the sentencing mix, but certainly I don't think there is any real light on how this evidence should actually be addressed, either in terms of the trial or in terms of a sentence, other than it's the right of the accused to call upon that evidence.
Yeah, exactly. It's something I suppose to keep an eye on to see what the Law Commission in England and Wales does, because as I say, they've focused specifically on it. So we'll see there. I suppose we're probably coming towards the end now, but I wanted to, two things I suppose. The first thing I wanted to ask you to reflect a little bit on your experience of dealing with these issues as a practitioner versus as an academic. So where do you maybe feel most comfortable and where do you think the most difference can be made?
Look, I loved my time as a practitioner, and certainly when we would appear in the High Court, and the High Court in Australia is our final court, it was really interesting because that's a point in time where you feel you can advocate for some sort of change. It's not simply about an appellate court has already decided this is the final appeal court and they can advocate for, you can advocate, for a particular position of reform. But more commonly, I suppose, as a practitioner, you're constrained by the particular case that you are acting in. And those constraints mean that it's not as if you can look at the big picture. You can't advocate for particular types of change. You are dealing only with the facts in issue in this particular case and trying to mount the best or the strongest and the most appropriate case for that trial. So in terms of practice, I really enjoyed my practicing life, but I suppose as an academic, one of the things that I really appreciate is that you can take the big picture, think big, and you can actually explore reform issues in a way that you probably can't as a practitioner. I guess the other reflection I would have is that because I've had that practicing life, I have a large number of connections within the legal profession, and I suppose that makes me not necessarily an insider, but I have a lot of connections, both practitioners, judges, etc., that enable me to feed back my types of research and translate it into appropriate forums. So I really enjoy the research, I guess, in terms of the big picture stuff, but I like it to be able to be translated into that practicing context. So I do a lot of training with practitioners and speaking to judges and judicial officers generally. So I guess both have kind of gone hand in hand, and I feel very privileged to have, had the capacity to do both.
Yeah, and I think it's just really important what you mentioned there about the idea of translating your research for practice, really, because that's something that I think as academics we need to do more of and think about, we have the privilege of taking the time to look at these issues and how we can ensure that the learning and the ideas that we have actually are seen on the ground and tested as well, I suppose, to see, can that work? And I'm actually co-director of a network with Dr. Susan Leahy, so the All Ireland Network on Sexual Violence Research, and that's one thing we try to do is bridge the gap between academics and practitioners and create space for, webinars, events, and even the conference that we have coming up. We've tried to ensure that there is a mix of academia and practitioners so that we can come together in a room and all talk about the issues that we're interested in and that affect people daily. So on that, so the second question that I had to ask to follow on from that was how other people can make a difference. So members of society, what can they do? How can they get involved in this area and trying to create an environment that is more responsive to sexual violence?
Look, it's a big question, and one of the things I always say is that certainly changing the law doesn't change what happens in society. So we do need to focus on how society operates, how things are changing or not changing. And I think young people are the key to a lot of this. And young people are really good, in my experience, of having very real conversations about sexual activity. And I think it's, consent education done very well is important, and not just in formal settings, but to, support young people and encourage them to actually think about sexual relations in ethical ways. And okay, you're not going to speak to everybody in that context, but I think that, young people need to get better at communicating, and they are quite good at it, I think, but they need to get better at it and to be encouraged to do those sorts of things. Otherwise, I think we have very little change happening from the legal system. Certainly concepts of consent as communicative consent and affirmative consent can be educative for society, but they don't change what's actually going on the ground. So I think, a much closer focus in on how young people communicate and to empower them to communicate in ways that give pleasure rather than distress and other sorts of things as a result of sexual activity.
Yeah, I think that there is definitely a real need for a focus on enhancing understanding and attitudes among the younger generation. And I think that across the university as well, from the network that I spoke about, there's a lot of really good researchers that are engaging young people. And in Northern Ireland, for example, some of the organisations, so Nexus Northern Ireland, have consent workshops. You've got Raise Your Voice, an organisation that has sexual harassment workshops, sexual consent workshops. So it really is an active area that is really important because, as you say, we can't do everything through the law. And that leads me to a final question for you, which relates to the debates around continuing efforts on the law reform. So like I alluded to earlier, the idea that the Gillen Review I've spoken to, some of the reviews that you've mentioned, there's a long list behind them. And people talk about review fatigue, for example. So I was wondering, and we spoke there about education of the youth and different things, but do you think that there is merit in continuing to reform law and procedure in this area? Or how far do we still have to go?
It's a great question, and just to give our forthcoming book a bit of a plug, it's the one that's very much at the focus of that book, which is to say, I guess in a nutshell, we have spent a lot of time trying to perfect and craft very good language around the concept of consent, but when I see how little traction that's getting in the courtroom versus things to do with, for example, special measures are working well, and the other area that we perhaps didn't talk so much about is that complete prohibitions on the introduction of sexual reputation evidence. In our studies, that's working well. Similarly, restrictive measures in relation to sexual history evidence are working as intended. So there are appropriate applications to introduce this type of evidence, submissions, rulings, and trials are conforming with those areas. Now, I know that's not the same in every jurisdiction, but certainly in New South Wales and Victoria, those measures are working well. And I think we really need to, if we're going to continue to try and reform the law, look more at the way in which the law might actually be able to better prohibit or introduce much more measures to constrain the types of questions that are enabled to be asked. Now, of course, this sits right up against the concept of the rights of the accused and to have a fair trial. But I suppose in our forthcoming book, we would argue that is the rights of the accused so enmeshed with having access to rape myths that means they have to have a fair trial only by drawing on those kinds of rape myths? Or do we actually need to reform the law in ways that actually prohibit these sorts of things coming into the courtroom in the first place? Because educative jury directions assume, in effect, that rape myths have already entered the courtroom. They're only educating and informing jurors after the event. So if we've all agreed that memory doesn't operate in the way that it's consistent, that it's, it has a capacious capacity to recount every single small detail, if we all, and the scientific evidence is that memory doesn't work in this way, why are questions still allowed to be asked about peripheral details in relation to the context of the sexual assault that have no relevance to any of the facts and issue. I think legislative reform needs to tackle some of those big issues about the type of legislation we're introducing, and it can't just be focused continually on reforming the notion of consent.
That's so interesting. Just listening to you, that was a really interesting way to think about it, because when you say it, it seems so common sense. Don't let these things in. Why are we've agreed they're not relevant, why are we still talking about it? So on that note, Julia, I want to thank you so much. That's been really, really interesting, and I look forward to discussions over the next couple of days.
Thanks for having me.